Again, my name is Lauren Mead. I'm an HR consultant. I've been in human resources for the last 19 years, consulting for the last 7. My goal is to just help employers understand the changes that are coming our way with California employment law and how we can apply that. So let's see, this is our holiday gift to you. Oops, sorry, there we go. All right, so in today's webinar, we're going to cover new laws that are beginning in January. We're also going to discuss laws that will be coming our way later in 2024. Industry-specific changes, minimum wage increases, and what's the latest with COVID-19 since that's still in our presence. Governor Newsom signed bills in the last couple of months for several items that we'll cover today. So thank you, Governor Newsom. We're also going to discuss action items for you to consider and how we can help in that area. I personally love updating handbooks, which I know sounds crazy. I know not everyone does, but there's actually not a lot to update, thankfully. So, all right. So the first big change that we have is SB 616, our paid sick leave law. California employers first began having to comply with paid sick leave laws in 2014. We had the Healthy Workplaces, Healthy Family Act, and that requires employers to provide 24 hours of paid sick leave to all employees that work in California for at least 30 days. So there really hasn't been a ton of changes over the last 10 years, and this is the first time that we're actually having an increase in the amount of paid sick leave that's required. So currently, if you have an accrual-based plan, you have to have 1 hour for every 30 hours worked. You can cap the usage at 24 hours per year, 3 days. You must allow a rollover if you have an accrual-based plan, and that rollover cap currently is 48 hours or 6 days. So starting January 1st, 2024, if you have an accrual-based plan, you're going to need to increase that amount to a cap usage of 40 hours a year. So it's still 1 hour for every 30 hours, but you can cap the usage of to 40 hours or 5 days in a year. Then you have to allow rollover for any unused time, and then you can cap that amount to 80 hours, which is a lot. I mean, we're talking 2 weeks of paid sick leave when you have an accrual-based plan, essentially. The alternative is you can have a lump sum front-loading plan. Currently, if you do that, it's 24 hours a year. Now that will increase to 40 hours a year. So we highly recommend, if you have an accrual-based plan, you may consider trying to switch to a lump sum plan. Also, if you have a PTO plan that has those requirements, if you need to bump that up, it may be better to evaluate, could I do a front-loading sick leave plan only in addition to a vacation plan? So if you have a PTO plan, the current rules are that you have to meet a minimum of 24 hours by the 120th day of employment. Now, beginning in January, a PTO plan must meet a minimum of 40 hours by the 200th day of employment. So that's about 6.5 months that they need to reach 40 hours by the 200th day. So your action items, you're going to want to review your current paid sick leave policy or paid time off policy and make appropriate increases. You can reach out to your HR consultant and we can help you with that. We can also help evaluate if your employees are going to meet that, the requirement to meet 40 hours by the 200th day. And if you are doing a PTO plan where you need to meet that 40 hours by the 200th day, you'll want to make sure that your employees are accruing at least 6 hours each month in order to meet that mark. Again, please consider using a lump sum front-loading plan to ease, tracking requirements. You don't have to let your employees roll over time. It's a lot easier to manage. Okay, so we have a new leave in place beginning in January for reproductive loss leave. It's SB 848, and it's effective for all employers with 5 or more employees in California or public employers of any size. So the requirements are that the employee has to be employed for at least 30 days and experience a reproductive loss event. So that could be a miscarriage. Maybe they tried, IVF and it wasn't successful. A stillbirth, even a failed adoption would be considered a reproductive loss event. Um, so they get up to 5 days of protected time off. It doesn't have to be paid, but it is protected time off. So if they, their job needs to be protected while they're out on leave. The time does not have to be consecutive, but it must be used within 90 days of the event. And then if you have an employee who experiences multiple losses, which can very well happen with like IVF treatments, things like that, you have to provide up to 20 days of leave in a year. So that would be the maximum amount that you have to provide is 20 days in a year. So this is a lot like bereavement leave, which came into effect this year. Really, the big difference is that you can't require proof for the loss. So your action items are to add a policy to your handbook for reproductive loss leave if you have 5 or more employees, and we can help you with that. So, I highly suggest you give your handbook to your HR consultant to see what updates need to happen, and this would be one of them. Okay, so we have 2 new laws that went into effect related to marijuana or cannabis use that go into effect January 1st. So the first is AB 2188, and FEHA, the California Fair Employment and Housing Act, was amended to add employee protections against discrimination based on off-the-job cannabis use. So big thing to remember, this is for off-the-job cannabis use. It doesn't apply to, employees who may possess marijuana or sell it or be impaired by. So if they're currently using the marijuana, they can't come to work high. So this doesn't apply to on-the-job cannabis use. It also doesn't affect the employer's right or obligations to maintain a drug-free workplace. So again, off the job. Most cannabis drug tests only show this lovely term, non-psychoactive cannabis metabolites, which those do not indicate present impairment. So when someone is tested for drugs and non-psychoactive cannabis metabolites are detected, they could have used marijuana weeks ago, and it's still showing up in their system. So employers can only use drug testing methods that do not screen for non-psychoactive cannabis metabolites. And drug screening companies are aware of this change. Most of them are aware of this law as well. So that's something that they'll need to make sure is updated on their end. All right, and then SB 700 under FEHA, the employer can also not discriminate using information about a candidate's prior use of cannabis that may be learned from their criminal history. So let's say you're hiring a new employee and you find out from their background check that they have possession of marijuana. You can't use that information to make an employment decision. Employers still have to comply with any state or federal laws requiring drug testing and background checks. So your action items are, you want to review your drug testing policies and procedures, make sure that they don't include any off-duty use or possession language. You want to make sure that your drug testing company is not testing for non-psychoactive cannabis metabolites. You also want to make sure that your managers are aware that they can't use, past use or any kind of related information about past cannabis use when they're making an employment decision. So this might come as a surprise to some managers. Maybe they think there's like a character issue or something like that. You just need to make sure that whatever you're basing your decision on does not reflect that being based on past cannabis use. The next two bills that we had passed were related to non-compete agreements. So the first is AB 1076, and in 2008, there was a court decision that ruled that non-compete agreements were void unless they met one of very few exceptions. Basically, AB 1076 reaffirmed this ruling, and they also, they made some clarifications, and then they also added to a set of laws in the Business and Professions Code to make it illegal to include a non-compete clause in an employment contract, again, unless very specific exceptions apply. Related, SB 699 introduces another law into that Business and Professions Code, stating that any non-compete agreement that violates California law is unenforceable in the state, regardless of where or when it was signed. So many employment lawyers are, they're kind of expecting that other states may kind of balk against this ruling if something was created in another state. So that's kind of, yet to be seen if that's going to be an issue with other states. So your action items are to review your new hire documents to determine whether there are any non-compete agreements or any clauses that exist that violate this updated law. You're going to want to review personnel files for any employees that are either currently employed or were employed after January 1st, 2022. If those employees entered into an agreement with a non-compete clause, they're going to need to receive a written notification no later than February 14th of 2024. So happy Valentine's Day. That written notice needs to express that any post-employment non-compete clause in an agreement would be void. You'll also want to consider modifying your agreements with current employees that might contain any kind of potentially void language related to non-competition. All right, the next bill that we had signed was SB 497, a presumption of retaliation. This is also known as the Equal Pay and Anti-Retaliation Protection Act. So basically, if an employee was to make a complaint about a labor code violation, and that covers a very wide spectrum of things, but some common ones are wage claim issues, someone's being paid more than me, working conditions, safety issues. If there is some kind of labor code violation and the employee makes a complaint, and then if they are disciplined or discharged, then it will create a rebuttal assumption of retaliation that the employee has been retaliated against. This basically would, if the employee was disciplined or discharged after making that kind of complaint, it would make it easier for the employee to establish a prima facie case of retaliation by creating that rebuttable presumption in favor of the employee's claim. If it was ruled that, the employee was retaliated against, the employer can be penalized up to $10,000 per employee per violation. So just think if you have, multiple employees that make complaints and then, it's ruled that a retaliation did occur, that's a pretty hefty fine. It's really important to make sure that your documentation is in place prior to disciplining and discharging an employee. If a complaint comes your way, we'll talk about more of that in a minute. Hopefully you're already aware that, if an employee files a complaint, whether it be discrimination, harassment, making a workers' comp claim, if you take disciplinary or discharge action against that employee after they've made some kind of complaint like that, it would typically be considered retaliation. And, it's your job to prove that you didn't retaliate. This law makes it clear that, that is something that you're going to have to fight against. You could have an employee who makes a complaint and then, all of a sudden their performance starts to suffer, and truly their performance could start to suffer. However, you really want to be careful at disciplining that employee right after they've made some kind of complaint, because again, you're going to be faced with that potential, fines and things like that, if it was to be ruled in their favor. So your action items, train your managers. Managers really need to be aware of what retaliation is and what could even be perceived as retaliation. Because again, as I mentioned, if you've got that problem employee, yeah, maybe they truly are a problem employee, but they've just made some kind of complaint. And so it looks like retaliation. So we need to train our managers on this is what looks like retaliation, even if that wasn't the intention. And then talk about those consequences. I think if you can really relay the fact that that's a employee can be, or the employer can be penalized, up to $10,000 per employee, I think that should raise some alarm bells for managers to be more careful about not retaliating. Reach out to your HR consultant if you need help with making documented cases against performance issues. We're very happy to draft, disciplinary warnings and things like that, and make sure that, you're really ready to point out how this was truly a performance issue and not something that's retaliatory. And, be careful to document performance issues as they occur. So don't come back, 2 months later after something happened and document it. It's more important to document it when it occurs. Sometimes employers will say, well, what happened to employment at will? Can't I fire somebody for, any time for any reason? A lot of my HR colleagues like to say that, employment at will is like a toothless tiger. It exists, but it really doesn't help you when you have situations where there's like wrongful termination and things like that. If you don't have your documentation in place, you can get in trouble. So document, document, document. All right, next we have workplace violence, and this is a big one. I imagine this is going to be on, everybody's webinars for the next 6 months or so. Two different bills were signed, SB 553 and 428, effective July 1st with SB 553. California covered employers have to establish a workplace violence prevention program, and that includes record keeping and training requirements. Just about every employer is covered except for healthcare facilities because they have their own requirements already, law enforcement agencies, and then locations that are not open to the public where fewer than 10 employees work at a given time. So if you're a covered employee, you are going to have to develop a workplace violence prevention program. It's not effective until July. However, this is something that everyone needs to be thinking about already. California employers are already required to have an injury and illness prevention program. And if you don't, please contact us ASAP. What this new law requires is that workplace violence prevention program be integrated with your IIPP. The good news is that Cal OSHA will most likely have guidelines and templates available in the near future to help employers with developing that. We're working on developing that. In addition to a written plan, there also are requirements for a log place of workplace violence events that has to be kept for 5 years, training requirements, and training records. So although Cal OSHA can begin enforcing the law July 1st, 2024, they actually have until the end of 2025 to propose standards and regulations for the plans. So that's always the interesting thing with California is we always have a new law, but then there's time to make some changes and things. So anyway, I'm sure we will be heavily discussing this over the next few months, so stay posted. The other part of workplace violence is SB 428. That becomes effective January 1st of 2025. So we've got, a whole year. Basically, it allows employers to seek a temporary restraining order, a TRO, an injunction on behalf of the employer if an employee faces harassment. So harassment in this instance refers to a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, or harasses the person, and that serves no legitimate purpose. So employers are already able to seek a TRO against an individual if that person is threatening violence or if there is an active situation of workplace violence. This takes things one step further, and if an employee is facing harassment, that's when the employer is now able to seek that TRO. So your action items, you want to review your IIPP or contact us if you weren't sure where you put that or need help with that. And you want to make sure that your employee handbook, if there's anything that's related to workplace violence, we need to be reviewing the IIPP and the employee handbook to see what we already have in place for workplace violence. And if you've had your handbook created by us, we have a policy in the handbook in what we use related to workplace violence, but that's definitely going to have to be beefed up. You'll want to begin preparing the workplace violence prevention program. So even though we've got some time before it's due, we still need to be thinking about what's going to be in that program. So things to think about are, who all is going to be involved with implementing that workplace violence prevention program. And, generally you don't want to have just one person implementing that. This needs to be a company-wide initiative where everybody's on their guard for potential workplace violence. You want to identify potential hazards at the workplace that could aid in workplace violence. So if you have, a lot of cash at your location, or, no security needed, or, you see employees letting people in without having to badge in, those are all things that weaken your defense against workplace violence. So taking a look and seeing what kind of hazards exist. You'll want to implement a system for workers to be able to inform management about workplace security issues and hazards and threats without fear of retaliation. So just making sure that workers feel comfortable even if they complain about somebody that is making jokes about workplace violence, that employee needs to know that they can come to you and feel comfortable in providing information without themselves being disciplined. You'll want to develop communication and strategies for emergency situations. So be thinking about, if there was an active shooter or another workplace violence situation, how would we inform our employees? What steps would we take? Do we have an escape route? Are there ways to keep somebody out of the door if they were to come in with that kind of intention? And so developing your strategy for what to do in an emergency situation. You want to train employees and supervisors on workplace violence matters. So again, making sure that they're aware that if they're hearing an employee make jokes all the time about bringing weapons into work, that's something that could potentially be a threat and needs to be addressed. So making sure that people are aware of what counts as workplace violence. You're going to need to create and maintain a violent incident log, and then keep records of all training and violent workplace incidents that occur. So, so many organizations, schools, churches, so many different places are already implementing strategies for, active shooter situations or intruder situations. And so this is something that all employers really need to pay attention to and be prepared for to develop. Reach out to us. We can help you with developing a plan and thinking through some of those things to look out for challenges so that you can be prepared to create a program by July 1st. Okay, so some industry-specific laws. The first is SB 723, Rehire Retention of Displaced Employees. This really applies to hospitality industry or security services. Basically, if an employee was laid off on or after March 4th, 2020, due to COVID-19, they need to have that option to be rehired or retained. Currently, this law is already in place through December 31st, 2024. So this just extends it by a year to 2025. And then the other industry-specific law is for payment for food handler card. So for any employers that have people handling food, they're typically going to need to have some kind of certification from California. And if it's the food handler card, then the employers must pay for training, testing, anything related to expenses for that employee to obtain that food handler card. The employee also has to be relieved of their work duties during the training and testing. So your action items, again, these are industry specific, but if you're in the hospitality or service industry, you'll want to review your records to see if there are employees who were laid off on or after March 4th, 2020, due to COVID-19, and who were employed for at least 6 months. Maintain that list so that when you have a job opportunity become available, you already know who you got to contact. If you are an employer with food handlers needing that certification, review those positions and just go ahead and be prepared to identify the cost and time associated with obtaining testing and certification so that you're not surprised and scrambling to figure out what to do come January 1st. All right, next we have minimum wage increases. So I've got 3 different, the most common ones that we'll have for our California employers. We've got the state of California, city of Los Angeles, and the county of Los Angeles for the unincorporated areas. These changes all go into effect January 1st. If you're unsure as to whether or not you're in an unincorporated area of LA County, there's a tool to check this online and we can direct you to that if you have any questions. If you're in an incorporated area of LA County, you actually fall under the state of California's minimum wage rate. We are always happy to help you with figuring out where your employees are located, with the whole unincorporated, incorporated, city of Los Angeles, etc. And if you have employees that are out of state, whatnot, we're happy to help. You can send us a list of your employees with your where they're located, and we're happy to help you get that up-to-date information. So I know I just showed the 3 most common, but there are so many more cities in California that have their own minimum wage requirements. So just keep that in mind. San Diego is one I can think of off the top of my head. For salaried exempt employees, they actually have to receive 2 times the state minimum wage per year. So in order to retain that exemption status. So the nice thing is, you only have to pay attention to the state minimum wage. So you don't have to look at the city, but it has to be 2 times the state minimum wage. So that's, $66,560. If your salaried exempt employee is not making that much, then January 1st, they won't be compliant to meet that salary exemption. If you have computer software professionals like programmers, computer engineers, and they fall under that exemption, the computer software professional exemption, starting January 1st, they must receive $115,763.35 per year, or hourly $55.58 in order to pass that exemption test. There is also a for national fast food chains, there is a minimum wage increase that's effective April 1st of 2024, and that will be $20 an hour if the fast food chain is a limited service restaurant consisting of 60 or more establishments, including their franchise locations. That's the new minimum wage for those workers. There was also a bill signed, SB 525, for healthcare workers, and they will receive minimum wage increases starting June 1st, 2024, and that will go until the year 2033, until they reach $25 per hour. And it's going to be on a schedule. So depending on what kind of facility the healthcare employer, or excuse me, healthcare worker is at, that's going to determine what their schedule is. So again, you want to review your employee work locations to make sure you've got the correct minimum wage information, and contact us if you need help with that. Very important to look at your remote employees. We hear a lot of times, oh, I had this employer, this remote employee that I thought was in California, and now they've moved to New York. I had no idea. So make sure that your employees are letting you know when they move, especially out of state. When you have the new state, you've got all kinds of payroll information you have to set up, new taxes, usually paid sick leave laws, all of that. So make sure that you always know your your employees' address, especially remote employees. You also need to make sure that if you have employees that are working in multiple locations, say you have an employee who's working part of the time in San Diego, for months at a time, and then maybe they work in LA another part of the year. You're going to have to comply with the paid sick leave laws and the minimum wage rates for those different areas. Sometimes there may even be new overtime requirements if somebody's out of state. So just make sure that you always have a pulse on where your employees are located. Okay, and then for our COVID-19 regulations, I'd love it whenever we don't have to talk about this, but really there's nothing new. Effective this past February, California adopted the non-emergency COVID-19 regulations. These will remain into effect until February 3rd, 2025. Record keeping regulations are in effect for another year beyond that to 2026. You're probably already aware that you no longer have to have the COVID-19 prevention program, CPP. You don't have to have that separate anymore. It can be incorporated into your IIPP as a workplace hazard. Even though we're in the non-emergency COVID-19 regulations, employers still have obligations. You still have to provide hazard prevention training to your employees. You have to provide face coverings when required by the California Department of Public Health, which, if there was a situation where there was like an outbreak or something like that, you would probably be required to provide those face coverings. Or if for some reason there was some kind of situation where COVID was rampant again, and that was deemed by the California Department of Public Health. If an employee requests a respirator like an N95, that has to be provided by the employer. You still have to identify COVID-19 hazards and develop ways to prevent transmission. Oops, I'm so sorry. Sorry about that. You still have to identify those hazards and then, look at transmission prevention, which usually includes ventilation requirements, just making sure you're on top of that. Investigate and respond to COVID cases and notify employees after a close contact. Make testing available at no cost and during paid time to employees following a close contact. So, we don't have to provide additional paid sick leave or anything like that, but you do have to provide paid time for testing if you have an employee who had a close contact in the workplace. You also have to exclude COVID cases from the workplace until they're no longer an infection risk, meaning they have to stay home during a specified amount of time, which we'll talk about in the next slide. And then maintain records of COVID-19 cases and immediately report any serious illnesses to Cal OSHA and to the local health department if there is a major outbreak, which is 20 or more cases in an exposed group within 30 days. So a lot of the times lately, I've gotten the question, "Oh no, my employee just tested positive. What do I do again?" Because we're in the midst of flu and COVID and RSV season. Um, Essentially, if the employee tests positive with or without symptoms, they can return to work after 5 days. If there are no symptoms or if they improve, and by no symptoms or improvement, that means no fever for 24 hours without using Tylenol or other fever reducing medications. They need to wear a mask through day 10. They need to continue isolating until they improve or until after day 10. And if they have a fever, they have to isolate until there's no fever for 24 hours without Tylenol. If the symptoms come back, they have to get tested again and then repeat the isolation all over again if they test positive. If the employee is exposed to someone at work with COVID and there's no symptoms, they should get tested 3 to 5 days after their last contact with the positive case, and then wear a mask for 10 days, even if no symptoms are present. So basically, no isolation if the mask is worn, but that is through 10 days. And if they end up experiencing symptoms, they just need to follow, typical protocol, get tested. If it's a positive case, start the timeline, as I mentioned above. All right, so how can we help? Number one, ensure that your handbook policy is updated. Again, please send your current handbook, or if you don't have one, we can help you develop one to make sure that your policies are updated. We can conduct an HR audit to review any non-compete agreements or other documents or forms and make sure you're in compliance there. We can help assist with the creation of the Workplace Violence Prevention Program, which is due in July, and also help you think through some of those things and help come up with mitigation procedures to help you reduce that risk. Evaluate current training plans, brainstorm or role play tricky performance situations. That's something that I love to do with my clients is, when there's a situation, sometimes it's easier to have kind of a role play so that you can be prepared of what that employee might say. And, as HR consultants, we've seen it all. We've heard all the things from the employees so we're usually pretty on the mark with being able to guess what they might say next based on what you have to say. We can review compensation information against the upcoming minimum wage increases and overall provide you with tools and guidance to comply. All right, so that in a nutshell is, what we have coming up, mostly in January. But again, we do have some of those big items like the Workplace Violence Prevention Program in July. We wanted to provide an overview today so that you can be prepared for what's to come in the next year and, see if you have any questions.
All right, so our first question here. An employee can make claims, but how long do we have to prove that the issue didn't happen before being fined?
Okay. And let me clarify too, if there's things that we feel like we need to research a little bit to give the best answer to, that might be the case. So if the employee makes a claim, so there's the 90-day period where you just really need to be careful that you're not taking disciplinary action or terminating that employee after they've made a claim. And I don't know if that answers your question, but really anytime an employee makes a complaint, they're always going to be a little bit more of a delicate situation where you just want to tread carefully. It's just like even before this ruling came into place, anytime someone makes a complaint, just make sure that whatever you're disciplining them for or discharging them for, that it's very clear it has nothing to do with the fact that they complained.
Our next question here, what if the disciplinary action has nothing to do with their complaint topic?
Yeah, and again, it's the basically with the law that came out, it's putting the ball back in the employer's court to have that proof. It's the burden of proof that falls to the employer. So, you could have the disciplinary action that has nothing to do with their complaint topic, but you're going to have to work harder to prove that it does not have to do with what they complained about. So you could still win, so to speak, but it's just going to be more work on your end.
Regarding the food handler card, wasn't all of that already a requirement?
And that I'm not sure of, but I can definitely circle back and get back with you. But what came out was the new requirement to pay for the time and training.
Isn't the $20 per hour going to trickle down? Why would I work here when I can go work at McDonald's for more money?
I agree. No.
I thought with COVID now, if positive case tests negative 2 days in a row, they don't have to continue to wear a mask for 10 days.
Um, we can look into that, but what was provided today was what is on California's website for the latest regulations.
For sick time, how much time would part-time people be entitled to? Is it the 40 hours?
Yes. So, very good question. Make sure that all of your employees, temporary, part-time, commission-only sales reps, everybody gets that minimum paid sick leave requirement. So if they work in the state of California for at least 30 days, they are entitled to either start accruing if you use the accrual based or receive that lump sum. So they receive the lump sum and they have to work 90 days before they're able to use that paid sick leave.
I thought companies could now decide how long someone has to wear a mask in the workplace if exposed to positive case but no symptoms. For example, 5 days or 7 days, not full 10 days.
Again, we're going off of what's on California's website, and I'd be happy to send that link to you after the call.
Do we have any more questions? Let's see. All right. Well, thank you so much, Lauren. Remember, if we
Absolutely. I hope everyone has a wonderful holiday. Thank you so much. If you have topics that you'd like us to consider for future webinars, please let us know.
Yeah, and if we didn't address your questions today, go ahead and reach out to us at info@calworksafetyhr.com. Be on the lookout for future topics on our website, calworksafety.com. Thank you for joining us. Have a wonderful rest of your day.